to the House Committee.
This Council resumes the second reading debate on the Court's Remote Hearing Bill. Professor Priscilla Leung, Chairman of the Bills Committee on the bill, will first address the Council on the committee's report. Professor Priscilla Leung. Deputy President, as Chairman of the Bills Committee on Court's Remote Hearing Bill, I'm going to report on the deliberations of the Bills Committee. The bill seeks to provide for the application for and the operation and effect of remote hearings. The Bills Committee held 6 meetings and invited written submissions from the public. Members were generally supportive of the bill and considered that the use of remote hearings in legal proceedings would be effective in enhancing judicial efficiency and the efficiency of the sector in Hong Kong and would help the court respond more effectively to various unforeseen and complex situations such as epidemics. Members agreed that proceedings relating to national security, whether criminal or civil, should not be conducted through a remote medium, and that criminal trials and hearings before the juvenile court should be classified as excluded proceedings under the bill. That is, they should not be conducted through a remote medium. Members noted that although criminal trials were excluded proceedings, witnesses might give evidence remotely if the judge considered it appropriate to do so and inquired about the intent of the relevant arrangement. The Judiciary Administration explained that criminal trials might involve a defendant who was in custody. While a defendant is in custody, a witness may need to attend the hearing remotely for certain reasons. If the witness is unable to give evidence remotely, it may affect the defendant's rights. For example, the defendant may have to be detained for a longer period of time as time is taken to arrange for the witness to return to Hong Kong to attend a physical hearing. Members raised concern about how to ensure a witness participating in a remote hearing was doing so voluntarily and without being subject to duress or interference. The Judiciary Administration responded that under Clause 9 of the bill, the court had to consider different applicable factors when making, varying, or revoking a remote hearing order for a proceeding, which include in Clause 9J the measures to be taken to ensure that evidence is given freely without coercion or other influence. Members were also concerned about how the judiciary planned to protect their system against security risks such as computer viruses or prevent data breaches when conducting remote hearings. Concern was also raised that criminals might impersonate witnesses in remote hearings using the deepfake technology. According to the Judiciary Administration, the judiciary attaches great importance to data protection and RT security, and has put in place a mechanism for the operations of remote hearings to prevent impersonators from participating in remote hearings. The bill also proposes to introduce new offenses to criminalize the unauthorized recording and publication of physical and remote hearings, as well as the recording and publication of broadcasts of hearings. The bill also provides for defenses for these offenses. Members were concerned whether the defense provisions were too lenient. The Judiciary Administration explained that in considering whether the act of making a record in court premises was unlawful, the Department of Justice would consider whether or not to prosecute with reference to the gravity of the breach and whether one had a reasonable excuse. Members observe that the proposed amendments to the Criminal Procedure Ordinance and the Hong Kong Court of Final Appeal Ordinance under the bill might deprive defendants, especially those who were not legally represented, the right to be present at an appeal-related hearing. In response to members' concern, the administration will move committee stage amendments to keep intact the relevant provisions in the two ordinances and add new provisions to empower the court to dispose of an application for leave to appeal on paper when it considers it appropriate. In the course of scrutiny by the Bills Committee, members raised a number of questions about the appropriateness and applicability of some of the legal terms and accuracy of the Chinese and English terms used in the bill. The government actively responded to members' comments and will move amendments in response to members' feedback. In addition, in response to other views expressed by members and the legal advisor to the Bills Committee, the administration will also move CSAs to make textual and technical amendments to enhance the provisions. The Bills Committee supports the administration's CSAs. Deputy President, the following are my personal views on the bill. At this day and age, we have been talking about smart everything, smart government, smart law, and that would also mean for smart judiciary. During the pandemic, the court was put on a halt. It has been almost 5 years, that period, and it has affected the rights of defendants. Those in the legal sector, including myself, have called for the judiciary to make sure there is a model for hearings to be conducted remotely. The response from the judiciary then was a legislative framework would be needed. They did not have the legal foundations then. With reference to other jurisdictions' practices, especially in the mainland, in terms of smart judiciary, they are moving very quickly. We can refer to their experience. I very much support this bill, the court's remote hearing bill, because this is the right direction to take. I do have several concerns that I want to raise. This is a trend to go digital, but we need to make sure there is justice. We also need to ensure there is respect for the court, judges, and relevant personnel. I just want to share with you some observations. The judiciary has now been broadcasting hearings. In mainland China, they have been doing that for several years. I would like to make a point here. Is it the case that every case would be appropriate for broadcast? I have heard some mainland judges tell me if they have all hearings of the court broadcasted, it would make for everything to be available on media. It does give pressure on lawyers because when faced with a camera, lawyers may not be able to speak freely. So I urge the judiciary to make sure they have reference to whether a case is appropriate for broadcast, say considering whether it is in the public interest to do so. I think not only the legal sector is involved, it also matters to the public. With remote hearings, it would mean for everyone's roles would still be the same as those attending physical hearings. I think the judiciary administration needs to enhance public awareness on this. Even if one is asked to give evidence remotely, one still has some requirements to meet and some statutory duties to fulfill. I have myself taken part in a summit that has used AI, and there were 8 versions of me speaking 8 languages, greeting those that were there. With advancements in technology, it may be easy for one to be subject to interference without people knowing in remote hearings. I think we need to make sure that there is still integrity and solemnness in remote hearings. While we are trying to go digital, how can we ensure security, prevent against hacking and data breaches? The Judiciary Administration said funding had been sought from the Legislative Council to implement security measures and to protect their system against external interferences. I think the judiciary has to make regular reports to the Legislative Council on their security measures and the implementation of the bill's provisions, because we need to ensure the operations are as intended. Next, with those giving evidence in other jurisdictions, in other locations, would there be people coming in and out, perhaps interfering with the proceedings, forcing the witnesses to speak something that they don't want to speak? Can we have people, say, those relevant personnel being present to ensure integrity of the witnesses, or can we have reputable law firms in the other jurisdictions provide premises for witnesses to give evidence in, again, to ensure integrity? The judiciary said that they would refer to the other practices of other jurisdictions to see if they can enhance the arrangements. I very much appreciate that. The bill would exclude criminal trials and hearings before the juvenile court. I very much support this. I think the Bar Association and the Law Society said that we need to make sure we are protecting the rights of defendants in criminal hearings as well as juvenile hearings. I think it is inappropriate to conduct remote hearings for these excluded proceedings at the moment. And we have also heard recently that everything would be in remote hearings. These are the concerns of the public, but that is not the case. We also see in the bill's provisions that the judiciary is just offering it as an option. Factors would have to be considered before allowing remote hearings to be conducted. Next, remote hearings need not continue if there are changes in circumstances. In fact, in Clause 9 of the bill, it already said a judge may make, vary, or revoke a remote hearing order. And in Clause 9E, if a witness has some changes in their physical or mental condition, or if the court has observed that the facilities where the witness is giving evidence may have their safety compromised, or the witness may seem to have been subject to interference, the judge would have discretion to vary or revoke the order. I think the bill is worth supporting. I would also like to take this opportunity to thank members for working very hard during the scrutiny. They have also raised various issues on, say, whether the terms are used appropriately, which may seem a minute detail, but that means a lot. I also thank the Judiciary Administration They have actively responded to members' feedback, and they have tried to respond to members' feedback by introducing corresponding committee stage amendments. I so submit.
Mr. Martin Liao. Deputy President, I first declare I'm a practicing lawyer or barrister in Hong Kong. One change brought about by the COVID epidemic was that there's greater acceptance of conducting conferences via technology by the public. Since year 2002 or 2020, the judiciary has allowed for remote hearing at various levels of courts. So far, over 2,000 remote hearings have been held for civil cases. Remote hearing is a major component in the judiciary's drive to apply technology. It will also enhance the efficiency of the judiciary. 4 guidance notes have been issued on the arrangements for remote hearing, and also the Chief Justice may, by virtue of the power empowered on him by the Court of Final Appeal Ordinance, can make directions for any court proceedings to be held remotely. But we still need a clear legal basis so that all levels of courts and tribunals can, on the premise of open justice and fairness, conduct hearings remotely. In particular, we pride ourselves as the regional legal disputes and dispute resolution center in the Asian Pacific region. We should be the first to adopt remote hearing in court. Now, the bill provides for the legal basis for the making and varying of remote hearing orders and also the arrangements. Part 2 of the bill empowers the court to make, affirm, vary, or revoke a remote hearing order. It also lists out the factors to be considered. It highlights the spirit of fairness and justice. Now, the court must consider the factors listed out in Clause 9 and satisfy that it is in the interest of justice to conduct the hearing remotely before making the order. Now, the court has to consider the views of all parties and also the ability of the parties to follow and engage in the proceedings, and also the protection of privileged communication between the legal representatives and the litigant parties, and also whether it would affect the credibility of evidence and witnesses. Also, the rights of fairness and also the security of communication should be upheld. Also, from the same perspective of justice, the bill also sets out for excluded cases where remote hearing cannot be conducted. For example, national security cases, and also excluded proceedings, that is, proceedings in juvenile court and also the criminal court. Vulnerable witness is also removed from the definition of participants in the bill. Now, according to Clause 16, 4, and 5, court can, on its own motion or on application from the parties, allow for the taking of evidence or cross-examining of witness via a remote means. The court must satisfy that all the factors listed out in Clause 9 is met. Now, I thank the administration for clarifying the bill and giving us real-life examples. Normally speaking, remote hearing does not apply for the first appearance in front of a magistrate and the first bail application. In putting up a defense and also at making a plea and handing down of judgment, the defendant should also be present in court. Now, the bill may contribute to unauthorized recording of court proceedings in court. So I support making unauthorized recording and broadcasting of court proceedings an offense. Is to ensure that even when hearings are conducted remotely, it is as fair and transparent as physical hearings. In accordance with members' views, the government is going to move CSAs to remove clauses 41 and 42 and amend 41A, B, C, D to keep the bill in alignment with the existing law so that defendants can keep the right of audience in court on application for appeal and substantive appeal. 2 rounds of consultation have been held. The Bar Association, the Law Society, and the major law enforcement agencies were consulted. They all supported the bill. After taking into consideration of all the stakeholders on the premise of enhancing the efficiency of courts as well as fairness, an appropriate balance has been struck. I support the amendments at the bill. I so submit. Dr. John Ng, Deputy President, judicial independence and the standard of our judiciary is well renowned. Now, with the digitalization drive, the judiciary has been adopting technology to enhance court efficiency. Remote hearing is one of the major tools. Besides enhancing communication between court users and the court, it also equips courts to deal with cases where courts cannot be convened. In case of emergencies, for example, epidemic and other public emergencies. Now, for a remote hearing order, that is an order to be made by the court to require for certain proceedings to be held remotely. This is already very common in overseas jurisdictions. In the mainland, Singapore and Dubai, the courts are already very advanced. In the mainland, the arrangement of remote hearing has been put into place a long time ago, and it greatly shortened the handling time of cases. Now, because of our legal impediments, most of our cases cannot be heard remotely. For example, the existing laws require the defendants to appear in person at various stages of proceedings. For civil proceedings, in principle, the law allows for remote hearing. However, the law does not provide clearly for the arrangements during a remote hearing. This bill has provided for the legal effect and the arrangements for remote hearing in court. Now, by appropriately adopting remote hearing in our court proceedings, we can enhance the court's effectiveness and save time for all court users. It will also facilitate overseas court users to participate in our judicial process. I support the passage of the bill. Now, with the rampant cybercrime in recent days, the Bills Committee is concerned about the security of court proceedings. There are worries about implementation of computer virus in the court system and also deepfake in evidence taking. Now, I urge the judiciary to pay attention to this trend. We have to guard against the use of deepfake to make perjury in court. Now, pursuant to our discussion, the government will move a number of amendments to enhance the bill. I support all of these amendments. In particular, the right of audience for defendants to appear before the court on leave for appeal application. Now, there are views that the relevant amendments would deprive the defendants of the right of audience, especially for those without a legal representative. In response, the government will move an amendment to keep the existing legislation intact while adding new provisions to empower the court in cases where it deems appropriate to dispose of these applications by way of paper disposal. This is the right way forward. Now, promoting remote hearing will also enhance Hong Kong's position as an intellectual property trading center and Hong Kong's position as an Asian-Pacific dispute resolution center. Now, with remote hearing, IP owners do not have to appear physically in court to give evidence in cases of infringement. It will enhance the efficiency of disputes as well as saving the traveling costs for the IP owners. It will also empower us to combat infringements of IP more effectively. Now, the government should step up publicity on Hong Kong's protection for IP. Remote hearing is the trend. Now, I support the judiciary's bid to enhance courts' efficiency, enhance service for the public.
多謝主席。
Mr. Lam Chen-Sing. Thank you, Deputy President. The bill will make use of remote hearings, and this will be of great help under unforeseen and extreme circumstances when the courts have to close. Under the existing framework, as long as we meet the relevant principles of justice and fairness, we can conduct remote hearings. With this bill, we will have the framework for the application for and the operation and effective of remote hearings and a list of factors that the court should consider when deciding whether to conduct remote hearings. Remote hearings will be more efficient, but there are, of course, limitations. In certain cases, it would be inappropriate to conduct remote hearings such as national security related cases as well as criminal hearings or hearings involving vulnerable witnesses. We now have an established mechanism for these cases, and I think that therefore these proceedings are excluded appropriately. We need to make sure support is provided to unrepresented litigants in remote hearings. For example, in the Labor Tribunal, between 2021 and 2023, there were 58 hearings that were conducted with video conferencing facilities. I believe it was due to the pandemic. In 22, we had the most number of cases, 38. In 2023, the number has gone down. In general, workers are not familiar with the procedures in the Labor Tribunal, and many of them, of course, cannot hire legal representatives. I hope that with the passage of the bill, the judiciary can disseminate information about remote hearings to parties, telling them about the operational details. The judiciary may also engage labor unions to disseminate such information to workers so that they can opt for remote hearings. In many cases, workers have already left the companies that they are having dealings with in the tribunal, and they are already working new jobs. If remote hearings are available to them as an option, it will provide convenience to them. With the Labor Tribunal's approval, I was hoping we can allow union representatives can represent litigants in Labor Tribunal hearings. And in remote hearings, union representatives can still represent the litigants, the workers. I very much appreciate the administration's stance on this. As for how we can make sure witnesses are not subject to duress or interference when they're giving evidence remotely, perhaps we may have someone interfering outside of the camera or giving the witness prompts in giving evidence. We need to make sure we are doing good gatekeeping. And in fact, Clause 9 of the bill also says that if the court has seen any circumstances that may render it unsafe to take in the testimony of the witness, the court may vary or revoke the remote hearing order. I believe that would ensure justice. During the deliberations of the Bills Committee, we talked about how being present at hearings or being absent from hearings may constitute contempt of the court. And it does say in the bill that being absent from remote hearings is the same as being absent from physical hearings. I agree with this approach because even if hearings are held remotely, they are still to be respected. And that would affect the due administration of justice. In the end, if one is absent, it may constitute the criminal contempt of court, but one may not be deliberately absent from a remote hearing. One may simply not be able to attend because of technical issues. If one has a reasonable excuse, the judiciary administration should be lax about this. And I'm glad the judiciary administration said the court would have considered various factors such as the circumstances of the case and the justifications provided by the individual and then make a ruling on this. I hope the judiciary in future will make good use of technologies to keep abreast with the times to make the operations of the judiciary more efficient. Thank you. Mr. Lam San Kang. President Xi in 2022 said twice that Hong Kong should maintain a common law system. Under the National 14th Five-Year Plan, Hong Kong is positioned to be developed into an international legal and dispute resolution center. This shows the country's determination to maintain Hong Kong's common law system and its unique advantages in the legal system. We are the only common law jurisdiction in China. We are also the only bilingual common law jurisdiction that speaks Chinese and English. We should develop into a hub to nurture legal talents. We should be pioneers in providing legal services. But we are met with challenges. We are moving very slow in digitalization. We are advanced in common law, but we are slow in the adopting of technologies. In the early 2000s, I visited Singapore. They were already making use of electronic record keeping system. The World Bank actually praised Singapore then that they were an example for digitalization of court operations. Way earlier than us, Hangzhou had already had an electronic court. It is the world's first online court, essentially. From the initiation of proceedings till the ruling is derived, it is completely online. We also have mobile courts in China. Different parties may attend hearings with their mobile devices or on computers as long as they can go online. In the 1990s, the Hong Kong courts have already started its move towards digitalization, but we see today many are still relying on papers, hard copies. And according to the World Bank's 2019 survey, our ranking or our score in digitalization is just 1. The full mark is 4. You can see how low it is. Justice needs to be handed out quickly and efficiently, or else it may not be considered justice. Hong Kong is the gateway between mainland China and the world. We need to make sure we're keeping abreast with the times and move towards digitalization. I very much appreciate the Judiciary Administration drafting this bill and implement the experience obtained during the pandemic and establish a formal framework for the operations of remote hearings so that judicial operations can be more efficient. This can benefit different stakeholders because it will save time and money, and it will provide for more accessible judicial services. In the past 3 years, the judiciary has been moving fast. I praise their efforts. I especially thank the Chief Justice as well as the Judiciary Administrator for working very hard for the past 3 years for this. With the passage of this bill, it is just a starting point. The next step will be to make sure we have adequate resources to implement the provisions in the bill. We need to make sure the legal sector is familiar with the new model. It will not happen overnight. We need to have adequate support from the judiciary to provide training, workshops, mock trials, or hotline can be held and installed to support the legal sector with their inquiries. We also need to make sure witnesses giving evidence remotely are not subject to interference or are not given any prompts. With the advancement of technologies, including the deepfake technology, we may even have people impersonating the witnesses. We need to work with different departments as well as maybe the Chinese consulates in other jurisdictions so that they can provide premises for the witnesses to give evidence that should enhance integrity of the witnesses. We have rapid advancements in technology. We should not limit ourselves to remote hearings. We should refer to the experience of other jurisdictions, for example, how AI is applied. Last year in Shenzhen, they have an AI ruling system. AI can provide full support in court, conduct analyses, and produce records of the proceedings right away. That has greatly enhanced efficiency. Zhejiang and Guangdong provinces have worked on a project to provide 3D data and make use of blockchain technology to allow relevant stakeholders to obtain encrypted data with ease. While the hearings may be remote, different parties can see the evidence in its 3D form even. In Guangzhou, when it comes to trademark cases, the court will use encrypted 3D data and will use AI to compare the authentic product and the suspected infringed product to tell the court how high of a percentage the infringement was, allowing the court to make a ruling. In Jiangsu province, AI is not only used to facilitate rulings, it is also used in enforcement and the sealing of premises by bailiffs, so that enforcement will not be delayed and people can't sell their assets in the interim of enforcement. I'm not saying AI can replace the relevant officers, but if we can make good use of the IoT and AI technologies, we can greatly enhance our competitiveness and we can catch up with lost time. Deputy President, Hong Kong's common law system is key to our competitiveness. With the developments of technology, we can improve our legal system even more. This bill is keeping abreast with the times. It also demonstrates our important next step of the legal system. Deputy President, I so submit, speaking in support of the bill.
Ms. Maggie Chan, Deputy Chair, I speak in support of the court's remote hearing bill, the bill in short, to offer clear legal basis for judges and judicial officers and to meet the demand from the community for courts to make better use of technology to enhance efficiency and to consolidate Hong Kong's position as an international legal and dispute resolution centers. Remote hearing is not something new in Hong Kong. Since 2020, the judiciary has been promoting the use of remote hearing, and we have over 2,000 civil proceedings that are using remote hearing. We have abundant experience, and it shows that the remote hearing can administer justice and enhance efficiency. I think that by the passage of the bill, we can make remote hearing as well as the procedures more clear and offer a legal framework for JJOs, especially in small claims tribunal and labor tribunals. When labor disputes is involved, workers have to take leave to attend the hearings, and this poses burden to them. If we make use of remote hearing, that will facilitate workers in participating in hearings. And remote hearings will also facilitate hearings under the Small Claims Tribunal. This is good for the people so that they can seek justice in a cost-effective manner for them to save time and money. I completely support the bill, and I agree with the exceptions set out. The exceptions include national security proceedings, criminal trials, and hearings before the juvenile court regarding regular procedures such as a 3-minute hearing. Remote hearing will be allowed, and this will enhance the efficiency of the court to make sure that efficiency and administration of justice can be upheld. And usually, some procedures are handled by phone, and our experience tells us that these have been very smooth. With the passage of the bill, we will be able to expand the application of a remote hearing in civil proceedings. And I also support Clause 9 of the bill. That is, the factors to be considered by the court before making, affirming, varying, or revoking a remote hearing order. I think that the list of factors is comprehensive. In terms of management of criminal or civil hearings, currently, before passage of the bill, the court has is empowered to make decision on the mode of hearing, but as different case has its own circumstances to ensure a fair justice, upon passage of the bill, the judiciary is going to issue a practical guidelines the directives made by the judge in the case management meeting will be very important. I hope that the judiciary will keep in close communication with the sector and offer guidelines on remote hearing so that people know about the relevant legal procedures. I suggest that the administration update the guidelines for judges so that when the judges make their decision, there can be enhanced transparency to make sure that the decision is fair. I hope that the judiciary will promote the use of remote hearing to litigants and persons, the community, and they should offer help to them and issue guidelines on the use of various facilities to make sure that we can use remote hearing more effectively. With technological advancement, I ask the government to review the use of remote hearing to make sure that it keeps abreast with the time and to make sure that the cybersecurity measures are up to date, and the government should also seek to collaborate with mainland courts to promote remote hearing in cross-boundary cases. Lastly, I hope that the government will promote remote hearing to the community and promote the use of it to court users and consider expanding use of remote hearing in the Home Affairs Department, Labor Office, District Councils, except LC court reception facilities, as well as law firms, economic office. There should be rooms and facilities in these offices to facilitate remote hearing. I so submit. Ms. Yong Hoi Yan. Madam Deputy, I speak in support of the court's remote hearing bill. This bill is not only a milestone in the advancement of technology and court, it also meets the expectations of the people, and this will enhance the transparency of judicial proceedings. Over the past few years, we are faced with technological reformation and the COVID. The court must reform. Since 2022, in various levels of court, during court civil proceedings, we have over 2,000 successful remote hearings being held. This shows that remote hearing can enhance efficiency, shortening the time of commute between the court and law firms, and to shorten the time of proceedings, as well as to allow witnesses living abroad to participate in the judicial proceedings. All these lay a solid foundation for this bill. So this bill is tabled to plug the loophole and offer a consistent legal framework for tribunals and courts so that judges can flexibly use technology to strike a balance between justice and efficiency. The framework set up under the bill include exceptions that are national security proceedings and criminal trials. Different levels of court can order remote hearing, order to hold proceedings and allow witness to give evidence via video conferencing. This will enhance efficiency and minimize legal disputes. The judiciary is going to develop a remote hearing system with encryption and multi-level identity verification and ask the witness and participants to show proof of identity. Members of the public will also be able to watch the remote hearing with links to ensure judicial transparency. The judges will also have to take into account the factors set out in Clause 9, including the views of the parties and nature of the evidence intended to be adduced before making a remote hearing order to make sure that justice will not be undermined with the use of technology. During the deliberations of the Bills Committee, we attach importance to as to how we can strike a balance between the protection of witnesses' right and efficiency. Witnesses for criminal trials are asked to attend hearings in person, and defendants as well, because judges need to look at the demeanor of the defendants to make sure that the proceedings and hearings are held fairly. We think that this exception will allow us to safeguard a fair justice in Hong Kong. Criminal trials are exempted under the remote hearing, but judges can order vulnerable witnesses to give evidence via a live television link. If witnesses, because of various reasons, can apply for the judge, for the court to give evidence remotely. During the Bills Committee's meetings, we are concerned about the Section 41 and 42 of the Criminal Procedure Ordinance and Section 36 of the Hong Kong Court of Final Appeal Ordinance regarding the right of a defendant to be present at hearing of an application for leave to appeal and at the hearing of an appeal. The judiciary have taken on board our concern, and they are worried if defendants or litigants in persons' rights will be affected because of the amendments. And I see that the government is going to keep the sections 41, 42 of the Criminal Procedures Ordinance and Section 83U of the Hong Kong Court of Final Appeal Ordinance, and allow the court to deal with appeals by disposal on water or paper. We are glad to see that the government has made such amendment so that defendants' right to appear in court will not be affected. There are also penalties under this bill. Including offense of unauthorized recording and or publication of court hearings and their broadcast. Once convicted, criminals is liable to a fine of level 5 and to imprisonment of 2 years. This will make sure that the court proceedings will not be destroyed maliciously, and it also set out that it's illegal to record any court proceedings. By this, we can ensure the integrity of the court and to enhance people's confidence in our legal proceedings. With technology, the court will be able to allocate resources freely and to shorten the waiting time, as well as alleviate the burden of the law sector. This will also allow people to know more about the remote hearing procedures so that they can get access to legal proceedings in Hong Kong. So I support the bill, and I hope that the relevant amendment to the ordinance will allow the court in Hong Kong to become an example. Thank you.
Mr. Dennis Leung, Deputy President. The FTU has always worked on the principle of fighting for the benefits and rights of the workers, and also fairness and justice. We support the bill. This bill is not only a piece of important reform tool for improving the judicial system, it is also an important measure to save costs for court users. Now, from the FTU's point of view, I will explain why we support the bill and also the society's concern of the bill. Now, for ordinary workers, they need to be away from work to attend court proceedings. They will suffer a financial cost. Now, for a grassroots worker earning a few $100s per day, if they need to attend court across the district, besides the traveling expense, asking for leave from the employer would also affect the employer's opinion on them. Now, remote hearing allows for participation in court proceedings by virtual means. It would lower the cost for attending court proceedings for the ordinary people. Now, the FTU attaches importance to the needs of the grassroots, including those carers who need to care for the charges. Now, because of busy work schedule, many grassroots workers have relinquished their legal rights. Now, with the remote hearing bill, we can uphold justice better. In the past, because of busy court schedule, the waiting time is long and there are often deferrals. Now, because of geographical issues, there is a huge backlog of cases. It undermines the rights of defendants and litigants. Now, remote hearing bill will enhance the speed at which court handles cases, in particular labor disputes and small claims applications. The enhancement of judicial efficiency will not only reduce the burden of court, it will also provide swifter justice for the parties. Now, in 2020, during the pandemic, remote hearing ensured that court proceedings could be maintained without being affected by the epidemic. Now, because of the epidemic, many cases were deferred. The long waiting time added to the psychological pressure of the parties. Now, with remote hearing arrangements, the courts can enjoy flexibility and handle the arrangements accordingly. Now, there are concerns about the security of data and privacy of remote hearings. Now, I believe that the bill has provided for sufficient safeguard. First, parties can voluntarily apply for remote hearing. It will not undermine the rights of audience of parties. Also, supporting mechanism will be established by the judiciary to ensure equal participation. 3, encryption technology will be applied, and there's strict restrictions on unauthorized recording. 4, when cases involve major public interest or are extremely complicated, judges may order the case to be heard physically. Now, the FTU will continue to help the public to understand the arrangements of remote hearing and clarify misunderstanding. Now, some are concerned that the solemnity of court proceedings would be jeopardized by remote hearing, and also the credibility of evidence and witnesses would be undermined. Now, the format is not as important as the integrity of the procedures itself. Now, in other jurisdictions like Singapore, their successful experience has shown that remote hearing will not jeopardize the integrity of trial. Now, according to the views of the parties, the judges have the discretion to decide whether the hearing should be conducted remotely. This is a user-centric approach in application of technology. Deputy President, the FTU believes that the bill is a major milestone for our judicial system. It is a response to the new era, and it is also a care for court users at various levels. It ensures that all court users can enjoy their rights and exercise their rights equally. Now, the FTU urges the government to do three things. First, ensure that the grassroots court users will not be affected by the digital chasm. Two, we need to update the practice guidelines according to the changes in technology. Three, the government should work closely with the labor organizations to provide dedicated supporting services for labor disputes cases and small claims cases. Now, the principle of open justice is to ensure inclusivity of our legal system. Now, this piece of legislation is exactly a big step forward, I so submit. Mr. Rokshan. Deputy President, everyone is equal before the law. Now, with remote hearing arrangements, we can participate equally, no matter where we are. Now, during the COVID pandemic, a lot of public activities were called to a halt. That includes court cases. 18% of court cases were delayed because of the epidemic. In the future, we may be struck by a new wave of epidemic. No one wants to see a repeat of what happened 5 years ago, where courts were at a standstill. That's why I support the court's remote hearing bill, which allows certain court proceedings to be conducted remotely. In the future, whenever there are public emergencies or a pandemic, which renders legal practitioners and parties to the case unable to attend court proceedings personally, they can still attend court proceedings remotely. Now, since the epidemic, the judiciary has introduced virtual and live conferencing technology to conduct remote hearing. Between year 2020 and 2023, more than 2,000 cases were heard remotely. Most of them were civil cases. For criminal cases, because of existing legal impediments, they cannot be conducted remotely. Now, for civil cases, in principle, they can be conducted remotely, but there is no clear guidelines for the arrangement. This bill provides for a clear legal basis for remote hearing. First of all, remote hearing can address the issue of manpower and resources shortage in courts and shortened waiting time. According to the data submitted by the judiciary, in 2023, there were some 520,000 cases handled by the court, representing a 9% increase from year 2020. The pressure of the queue has become more acute. Now, with the option of remote hearing, litigating parties can attend court proceedings from a suitable location. They can attend cases heard by the district court as well. It will address the shortage of resources of court, as well as greatly shortening the waiting time for cases. Making reference to the mainland experience, remote hearing has long been a tool for improving judicial efficiency. Now, beginning from this year, the mainland has conducted a fully remote trial, allowing remote attendance in court proceedings by judges, lawyers, and defendants alike. Now, it shows that the average time taken for this kind of trial is just 29 minutes, representing a 3/4 saving in time compared with the traditional model. Now, we need the appropriate hardware for remote hearing. We need to invest in a high-speed and stable network for remote hearing so that the quality of trials will not be affected by latency. The venue must also be soundproof to prevent eavesdropping. Also, the personal safety of witnesses and court users must be ensured to avoid interferencing. The hardware must be updated regularly to ensure that the network is fast and stable so that every party can speak and listen to court proceedings, clearly, solemnness must be upheld. Judges and lawyers must abide by the attire etiquette. Court users must dress in a presentable manner, and they cannot engage in unrespectful behaviors. Otherwise, they would be evicted from court. Now, since court users are located at different locations, it may be difficult to uphold the solemnity of court proceedings. And usually, judges would have direct interaction with the witnesses. They need to pay attention to the demeanor, facial expression, or even pauses in the witnesses' evidence to determine their credibility. Now, with virtual proceedings, there are limitations like the camera angle and also latency of network. It may affect the just judgment. So very specific rules must be laid down. For example, the attire of court users must be specified, and also the fitting out of the room where witness gives evidence must be specified. There must be widespread publicity to ensure that everyone is compliant with the law. I submit supports the bill.
Mr. Benson Look. Deputy President, I speak in support of the court's remote hearing bill. I was a member of the Bills Committee and participated in the scrutiny of the bill. The bill provides for a legal framework and would provide for a list of factors to be considered by the court when the court makes a decision to make, vary, or revoke a remote hearing order. With this, the conducting of remote hearings, it will help save commute costs for parties, especially for those living in remote areas or have mobility issues. This will be especially beneficial. And touch wood, if we have another pandemic, we will no longer be affected. So I speak in support of the bill. For those who have had court cases, have had to deal with court cases, they think this bill will be really beneficial, and they urge for early implementation of the bill. I have raised some concerns as a Bills Committee member. However, I wanted to know how much more efficient will court operations be with the conducting of remote hearings, and how much can we save? The Judiciary Administration said they do not have the relevant analyses, or they can't really say for sure what costs can be saved. But at least for the 3-minute hearings, lawyers will no longer have to go to the court to be present at the hearings. That will definitely save on the commute fees as well as legal fees. For remote hearings, we may have other issues. We need to make sure the witnesses are not subject to interference. The Judiciary Administration said in Clause 9J, the court will consider the measures to be taken to ensure that evidence is given freely without coercion or other influence, for example, by installing 2 cameras at the front and behind the witness. There may also be a camera trained on the computer screen to make sure there is no inappropriate behavior of the witness. Also, if circumstances warrant, so the court may revoke the remote hearing order, and if any parties find it inappropriate to conduct a remote hearing continuously, they may raise their concerns with the court. I believe with this approach, this should allay the concerns of the public. Many members are worried that the deepfake technology may impede the operations of remote hearings. With a system upgrade, we need to make sure the system is upgraded to the standard that the courts can still ensure fairness and justice of the legal system. With our move towards having more remote hearings, I would say that this bill is just the first step. In future, the courts will move towards further digitalization and making even more use of technologies. I believe that should help deal with the backlog of cases in the courts at the moment. I so submit, Deputy President. Mr. Holden Chow. Deputy President, I speak in support of the court's remote hearing bill. I would like to thank the Judiciary Administration for taking on board many of members' suggestions. I will talk about the details later at the next stage. During the deliberations of the Bills Committee, many members raised different concerns. We think remote hearings would be very much appropriate for civil hearings, but not so appropriate for criminal hearings, because in criminal hearings, the defendant's rights may be deprived with the conducting of remote hearings. I thank the Judiciary Administration again for taking on board many of members' suggestions and exclude the proceedings of criminal trials and hearings from the conducting of remote hearings. For 3-minute hearings, however, it is a different story because the 3-minute hearings do not really affect the proceedings of the specific cases. And we talked about during the Bills Committee meetings, we need to make sure remote hearings, the participants in which would need to obey with the directions of the court, making sure that witnesses would not be subject to interference. During the Bills Committee meetings, we actually talked about, if possible, we should have third-party premises, say law firms in other jurisdictions, to provide premises in which a witness can give evidence remotely, so as to, as much as possible, ensure witnesses will not be subject to interference. I'm happy to see that in the bill there are some provisions that would address the relevant concern. I do see that the government taking heed of the advice of members in 83R. In general, the litigants will be able to be present at hearings, but it seems that in the bill originally there were amendments to section 83R. But many members raised concerns that it may give a wrong impression that the right of defendants to be present at hearings may be deprived. In order not to give off the wrong impression, many members called for the Judiciary Administration to make amendments to the relevant provisions. So we are now retaining the provision of Section 83R and added another section of 83RA to empower the court to dispose of an application on paper. I think that should allay the concerns of the public. I would also like to thank the Judiciary Administration for considering the feedback of members. This should also make sure we are not giving off the wrong impression that the right of defendants may be deprived. This is very important. Deputy President, I speak in support of the bill. I so submit.
Dr. So Chang-Ming, thank you. Deputy Chair, I speak in support of the court's remote hearing bill. Remote hearing in courts is a global trend. It makes legal proceedings more convenient to all parties, including participants located elsewhere. This will also save time and costs among various parties, including the litigants, the law firms. And when social unrest happens, say for example, epidemic, we will be able to make sure that the court operate normally with remote hearing. Second, there is increasing demand for court services. Digitalization of the court will allow us to enhance its efficiency. Remote hearing is one of the tools to achieve this goal. Since 2020, the Hong Kong courts have been using remote hearing to deal with over 2,000 civil cases. We have accumulated abundant experience, and we have a solid foundation for this bill as a result. However, remote hearing is something new. The key of success lies with whether we can administer justice fairly, so that the members of the public will have confidence in remote hearing, in the sense that there is no difference between remote hearing and physical hearing, to safeguard the status of law in Hong Kong. The bill covers various details of remote hearing, including the applicability of the remote hearing and exemptions to remote hearing, including national security proceedings and criminal trials. These proceedings and trials will be exempted under the remote hearing. I think that this is the right approach. Madam Deputy, I support the bill, and I appeal to the administration to adopt the following suggestions. First of all, remote hearing relies on technology. We must attach importance to the crime that may arise from the use of technology. Although the government is going to develop its own remote hearing system and will enhance cybersecurity, as of today, we've seen deepfake technology developed by artificial intelligence. There is no way for us to rule out any fraud in remote hearings. The government said that they will use 2 cameras to capture the face of the witness and another to capture the other side of the room in order to cover every corners of the room to prevent any fraud. However, technology develops in leaps and bounds. In the future, we may be able to develop fake scenarios that may pass off as real and are not detectable. We need to develop an identity verification system, such as bio-identity technology, such as a facial recognition technology adopted by the mainland, I think that we can learn from them. We should also work with the mainland to develop advanced bio-identity technology to prevent any fraud. We should continue to make use of AI to plug any loophole and improve the efficiency and quality of remote hearing. Also, I think that we should make reference to the success of online hearing of the mainland and other countries and develop a more mature system to allow people to resolve their legal disputes. Hong Kong and the mainland adopt two different legal systems. We shouldn't be comparing the two directly. However, remote hearing has something to do with technology. I think that we should learn from the smart court adopted on the mainland. Say in 2021, the administration enacted legislation to promote the use of internet court and smart court. The mainland governments offer support to such smart court, and they're able to resolve people's dispute effectively. We already have a very effective internet court on the mainland, and people are very used to it. However, in Hong Kong, remote hearing is just an extension to the physical court. I think that in the future, we should learn from the mainland to make use of advanced technology to offer online hearing and dispute resolution services with low cost. Lastly, remote hearing is a new judicial service and will be a new approach to handle judicial proceedings. I think that the government should step up education and publicity to promote it to the people so that they will make more use of remote hearing. The government should also provide support service, such as by offering facilities to people in need, such as a separate room and scenes. Currently, the Correctional Services Department has 3 reception facilities with rooms for people in custody. In court, there are 7 rooms for people in need to use them. However, it's obvious that we don't have enough support. I think that we should set up rooms in various district offices for remote hearing for people to apply for and use them. Thank you. Mr. Tan Ka-piu. Thank you, Madam Deputy. Mr. Dennis Leung of the FTU participated in the Bills Committee's scrutiny of the bill. I'd like to raise one point. I hope that upon passage of the bill, we can focus on handling cross-boundary remote hearing. Some imported workers work in residential care homes for the elderly, and employers sometimes confiscate their ATM cards, and they try to claw back some of the commission from the imported workers. And as soon as the workers make a complaint, the employers dismiss them. They thought that the workers would not sue them. So I think that we have to make sure that our imported workers will not be exploited. And I think that such labor disputes should be handled via remote hearing so that workers will have confidence in working in Hong Kong. And this will send a message also to the employers that they should not exploit the imported workers, because the workers will be able to get what they are entitled to back via legal means. The FTU is committed to help. We have 6 advisory centers on the mainland. Our employees will participate in the remote hearing together with the imported workers in Huizhou. It's not difficult for us to install, say, 2 cameras in the room. So I hope that upon passage of the bill, the government will accord priority to cross-boundary remote hearing to ensure the interest of the imported workers. Thank you.
Dr. Hui Simon Lee. Thank you, Deputy President. I speak in support of the bill. Remote hearing is in fact widely adopted in overseas jurisdiction. Of course, it would bring about new challenges. However, in the process of scrutinizing the bill, I'm pleased to see that the government has addressed members' concerns and worries about the bill. Responses have been made accordingly. Today's bill is more than a reform on the judicial system. It is also a very solemn step forward. Now, the major technological challenge to remote hearing can be categorized into 4 areas: feasibility, data security, and operation standard. First, technical feasibility. Is the technology mature and sophisticated enough to replace traditional court proceedings? At present, our visual conferencing system supports high-resolution conferencing. However, the standard for court proceedings should be much higher than that of ordinary conferences. Technological issues like latency may render the accuracy of witnesses' evidence jeopardized. And also there would be questions about the true identity of the witnesses on the stand. Now, for these issues, the judiciary administrator can issue directions concerning the standard of technology and hardware to be used, and also the emergency response plans. Second, on data security. Confidentiality of judicial proceedings is of utmost importance. Court proceedings involve a large amount of sensitive information. There would be double encryption on both ends to prevent leakage. All the information will be stored in an encrypted manner and can only be accessed by court users. There are also anti-hacking measures. According to the requirements in the ordinance, hacking the court system, impersonating a witness, or unauthorized recording of court proceedings, or even screen capping would come with legal responsibilities. How can we ensure that there is a consistent standard between remote hearing and physical hearings? We need to have a very clear standards on remote hearing to uphold the integrity of court proceedings. For example, remote court users will be required to appear before the court in an environment which is quiet and undisturbed. Failing to secure such an environment, the court may provide assistance. Also, the court may direct the witness to move the cameras to show that there is no interference to the witness-taking process. Also, the proceedings may take place in a law firm. Now, besides the technical issues we have raised, I believe that the bill has struck a balance between the 2 following points. One is maintaining an option for the court users. Now, the court may, in its own motion or on application by parties, order that the proceedings be conducted remotely. Now, the court needs to consider various factors before reaching that decision. 2 is the solemnity of court proceedings. Some worried that in a remote hearing, some court users may appear before the court from the comfort of their homes. That may jeopardize the solemnness. They may dress casually and give witness or give evidence in a noisy environment, but these will be regulated through practice guidance. Remote hearing will enhance court efficiency and lower the cost of attending proceedings. Now, with the option of remote hearing available, for employees overseas who cannot come back to Hong Kong on a regular basis, they will have better access to justice. So I think this is a very proactive move, I so submit. Dr. Junius Ho. Deputy President, I speak in support of the court's remote hearing bill. There is just one thing I would like to point out. Despite my support for the bill, there is a concern, but that may have been addressed by the Bills Committee already. I was not a member of the Bills Committee, but I would like to point out that concerning the remote hearing order, the purpose is to allow court users who cannot attend the court physically because of various reasons to have equal access to justice. Now, the factors to be considered are listed out under Clause 9 of the bill. So Clause 9 includes subclauses A to O. P is any other relevant considerations. So who is eligible for giving evidence in court remotely? The factors to be considered by the court are factors A to O and also other considerations under point P. Now, Clause 5 of the bill, whenever national security proceedings are involved, the arrangements of remote court hearing does not apply. That is great, but it is somewhat insufficient. For cases other than national security cases, if the party is a wanted person under the National Security Ordinance, if they are in Canada, if they are involved in a civil litigation, which is not a national security case, if they are unrepresented by a lawyer and they would like to give evidence in court, will they be allowed to give evidence remotely? Now, Clause 9, factors A to O, do not cover this scenario. But it has come to my attention that if the order is would potentially jeopardize the assessment of credibility of the evidence, the court may deny the application. So this may address the potential abuse of the rule. Anyone who appears before the court needs to declare that they are testifying to the best of the knowledge and they cannot give false evidence. Otherwise, they would be committing perjury, and that would come with an imprisonment term. Now, subclause Q, for wanted persons involved in civil cases, well, naturally, they will not come back to Hong Kong because they would be arrested on arrival. So how can we plug this loophole? Now, Clause 6 brackets K. Clause 9 brackets K. The potential impacts of the order on the assessment of the credibility of a witness and the reliability of the evidence presented. That is a factor to be considered. Now, we are going to pass the law today. So maybe I'm too late. I support the passage of this bill. But we need to bear in mind this category of persons. Are wanted persons eligible for testifying remotely? We have to consider the credibility of these wanted persons. They are fugitives. And also the impact on society as a whole. Thank you. Mr. Paul Chair. Deputy President, like the previous speaker, I thank the judiciary for their efforts in further promoting the application of technology in court proceedings.
We are also moving with the times. We also have now more options. I believe your bill will be facilitating, providing different options. There will be contingency options. In fact, we talked about how during the pandemic we would hold remote hearings. We want to explore different possibilities so that we will have a platform that is more formal. I do support this. I think the overarching principles would be fairness and efficiency. In fact, efficiency would factor into fairness because if we are too slow, that it wouldn't be justice either. We have seen some hearings being excessively long. That is unfortunate. We have seen for some national security cases, the defendants cannot apply for bail, so they will be detained the whole time. It is unfair to them. It also affects due administration of justice in accordance with the common law. I think we need to talk about how we can have a shorter waiting time for court hearings, especially with 3-minute hearings. When I was a newbie, we have often talked about before registrars or masters. It would just be a very short hearing. It would just be about submission of documents, making verbal submissions. But lawyers would have to commute to courts anyway. This is an example. For proceedings that would not have much of a dispute, maybe just a mention in a civil case, if we require all parties to be present, it can be a waste of time and money. As Mr. Tan Ka-piu said, for some workers who would have tourists who had money stolen because they don't want to come back to give evidence in future, conducting remote hearings may resolve this issue. Dr. Simon Lee mentioned some technical issues, say with security or operability. We have actually highlighted many of these issues during the deliberations of the Bills Committee, and I thank the Judiciary Administration for introducing many CSAs to address members' concerns in this regard. But apart from thinking whether the case is criminal or civil, whether the case is national security related, I think this line of thinking is too restrictive. We have in criminal cases or national security related cases that may not require to be excluded. We have, say, for bail hearings that would only require submissions from the legal representatives. Do the defendants actually have to be here? I don't think so. And in the first hearing, if one is to take plea, one can the defendant has to be there because it is essentially arraignment and the whole matter is very serious, and one may apply for bail. And at one point in time, there were complaints. Defendants said that while statements were taken by the police. They were heard by the police. There was abuse, and the defendants would actually tell the judge then and there at the first hearing that they were beaten and protection orders might be issued. But in Hong Kong nowadays, we do not really see this anymore. So do we really need defendants to be present for these types of hearings? Even for a national security related case, we would see every time we have many parties being present, and for the more serious cases, we have defendants being escorted by police vehicles and armed police officers. Is that really necessary? We need that we have so many officers to escort a defendant in a national security case. I don't think it's really necessary for the defendants to be present at these types of hearings. I think for certain types of hearings, for national security cases, we can still conduct remote hearings. For civil cases, I think some processes can be done with remote hearings. As many of you have done video conferences on a board and another general meeting, in fact, it will be less solemn. It will be more casual. But for remote hearings, you have nothing but the camera and the screen. I think with discovery stage of civil and criminal hearings alike, it is very important. It is when we can find out whether witnesses are telling the truth. And I think fellow lawyers would know, even for a civil case at the discovery stage, for a lawyer to converse with the witness in person or with the judge asking questions, the nonverbal cues would tell a lot. When they pause, their emotions, they're sad, they're angry, or they are not answering the questions, or they're stuttering. It will all help the court to decide on the credibility of the witness and whether to accept their testimonies. I think we need to gauge this factor rather than just delineating the cases based on whether they are criminal, civil, or national security related. I think in some cases, as I said earlier, we have bail hearings, mentions, or adjournment hearings. Whether it's criminal cases, civil, or national security related cases, these are miscellaneous hearings, so they do not require defendants to be present. I urge the Judiciary Administration to include these for remote hearings as well. We, of course, want to have a more streamlined judicial process, and we also want to move towards digitalization. I think there are suggestions. I have some suggestions on what we can do in future. We have been doing e-filing of documents. I think that is a good thing to do. With the making of transcripts, we can perhaps make good use of AI or programs. And I think the judges are already making use of the relevant program, but this program is not shared with the legal sector at the moment. I hope that it can be shared with the sector because it can greatly enhance efficiency and save costs. In the US, they have been implementing this for long. For civil cases, they would have a deposition stage. So matters can be disposed of without one being present at court. Everything can be video recorded. It has really been able to save time. We can make good use of these different ways to enhance efficiency.
If no other member wish to speak, I now call upon the Chief Secretary for Administration to reply, then the debate will come to a close. Chief Secretary. Deputy President, first of all, I would like to express my heartfelt gratitude to Dr. Priscilla Leung, Chairman of the Bills Committee on the Court's remote hearing bill, Mr. Lam Sang-kun, Deputy Chairman, other members of the Bills Committee, as well as the Secretariat for their hard work, which has led to the smooth completion of the scrutiny of the bill. I would also like to thank members of the Bills Committee, as well as the 15 members who have spoken, for their invaluable views on the bill. When moving the second reading of the bill, I mentioned that the bill seeks to provide a clear legal basis for judges and judicial officers to order remote hearings at all levels of court and tribunals as they see fit, taking into account all relevant factors and the two major principles of open justice and fairness of hearings. At present, most criminal proceedings cannot be conducted remotely because of legal constraints. In the case of civil proceedings, although there is no restriction on remote hearings under the current legislation, there are no express statutory provisions on how matters should be dealt with remotely. The bill provides for the application, operation, and effect of remote hearings, including the scope of application and the exemptions to which it does not apply. The factors to be taken into account by the court in making, varying, or revoking a remote hearing order, and the introduction of some new offenses and penalties. Some members are concerned about the cybersecurity issue of a remote hearing. I know that the judiciary attaches a lot of importance to cybersecurity. We have made reference to the relevant policies and guidelines of the government, and we update the judiciary facilities and guidelines in time. And we do have regulations on the system specifications to make sure that remote hearing will be held fairly. Since 2020, the judiciary has conducted more than 2,100 remote hearings at various levels of court, and the experience has been positive. The bill will be applicable to civil proceedings immediately after its enactment. For applicable criminal proceedings, as mentioned by Mr. Paul Che, the judiciary expects that remote hearings can be used about 6 months after the enactment of the bill, so as to allow sufficient time for stakeholders to prepare for and gradually adapt to remote hearing. Upon passage of the bill, the judiciary will make more frequent use of remote hearings where practicable, and will prioritize the use of it in appropriate proceedings, particularly those that are short, such as 3-minute hearings. There were members who talked about the exceptions to the bill, and they agreed to the exceptions. After consulting the relevant stakeholders, the judiciary think that we should not include hearings before the juvenile court and the criminal trials, as well as national security proceedings in the remote hearing. So the list is set out in Schedule 1, and the Chief Justice can amend the schedule by negative vetting. Apart from this, if national security proceedings is held remotely, there will be risk. That's why Clause 5 of the bill sets out that national security related proceedings cannot be held remotely. Under the ordinance, under the law, or otherwise. I think that this addressed Mr. Paul Che's question. There were also members who asked if we should update the guide to judicial conduct to regulate the conduct of the judges during the proceedings. In Part C of the Guide to Judicial Conduct, it sets out the guidelines to the judges' behavior. Although the mode of hearing is not mentioned, all judges in remote hearing and physical hearing have to meet the relevant requirements under the guide. The judiciary will review the Guide to Judicial Conduct whenever appropriate. Some members are concerned about the practical guide remote hearing. According to Clause 32 of the bill, the Chief Justice can issue practice direction regarding remote hearing, including the definition of remote medium, as well as the proceedings to follow. The Chief Justice can also designate proceedings that should be held under remote hearing. The remote hearing bill will apply to mostly civil proceedings. The judiciary, 6 months upon passage of the bill, will start using remote hearing to make sure that the stakeholders will have ample time to prepare for it. The judiciary will also issue guidance on the application process of remote hearing as well as relevant matters. There were members who were concerned about the promotion efforts of the government about this bill. Upon passage of the bill, the judiciary will step up promotion of remote hearing. As I've mentioned, the judiciary will use remote hearing more frequently whenever appropriate. I'm grateful to the Bills Committee for holding 6 meetings to scrutinize the provisions of the bill in detail, thereby perfecting it. I am pleased to note that the Bills Committee supports the early passage of the bill to enable the judiciary to fully implement and regulate remote hearings early. In respect of individual provisions of the bill, the judiciary will move amendments after taking into account the views of the Bills Committee members. The amendments which I will move later at the committee stage mainly concerns 3 areas, including the definition of legal representative, the defendant's right to be present at the hearing, and some textual amendments. President, I urge members to support the bill and the amendments that I will move later at the committee stage. Remote hearing is one of the major initiatives of the judiciary to promote the use of technology to enhance the efficiency of court. The bill meets the expectation of court users and the community in recent years for the wider use of technology in the judiciary. The bill, upon passage, will not only enhance the efficiency of litigation proceedings in Hong Kong, but also bring the use of technology in courts to the next level. Meanwhile, it will help the courts to cope more effectively with various complex and unpredictable circumstances affecting the operation of the courts. President will submit.
I now put the question to you that the court's remote hearing bill be read the second time. Would those in favour please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Court's remote hearing bill. The Council now becomes Committee of the Whole Council to consider the